Communities are facing devastating floods, prolonged droughts, rising sea levels, biodiversity loss, and the destruction of livelihoods. Yet Africa has contributed only a small fraction of the world's greenhouse gas emissions. The stark imbalance reminds us that climate change is not only an environmental issue, it's also fundamentally an issue of justice, equity, as well as accountability. And for too long, those who have contributed the least to the climate crisis have carried some of its greatest burdens. While many communities continue to bear these consequences, the global response has too often fallen short of what justice demands. This is why conversations about responsibility, accountability, and reparations have become more urgent than ever. Last year, the International Court of Justice delivered a historic advisory opinion on climate change, affirming that climate action is not simply a political choice or moral aspiration, it is a legal obligation. The court clarified that states have duties to prevent environmental harm, to protect human rights, and cooperate in addressing the climate crisis. Importantly, it also recognized that where these obligations are breached, states have many responsibilities as well as to provide remedies, reparations for the harm caused. But the advisory opinion is not the end of the journey. It is the beginning of a new chapter. The real question before us is no longer what the law says, but how we use the law to deliver meaningful change for communities on the front lines of the climate crisis. This discussion is particularly timely as the African Court on Human and People's Rights prepares to consider its own advisory opinion on climate change. Today's session forms part of the global 24-hour webinar festival, marking 1 year since the ICJAO advisory opinion process. And around the world, partners are reflecting on how this landmark decision is already shaping litigation, advocacy, policymaking, and community action. Every session contributes to one shared objective, transforming the advisory opinion from a legal milestone into a practical solution and practical actions. This session has been prepared by the World Youth for Climate Justice and is supported by a number of different civil society organizations. We're really fortunate to have an exceptional panel of speakers whose work spans across litigation, advocacy, academia, as well as youth leadership. And I'm delighted to introduce them. Our first speaker of the day is Taoufik Alatise. Taoufik is a lawyer as well as a PhD candidate at the University of Ilorin in Nigeria. Taufik's work focuses on environmental law, human rights, climate governance, as well as international law. He also serves as a rapporteur for the Sabin Center for Climate Change Law at Columbia University and has previously served as a legal advisor to the World Youth for Climate Justice Africa Front. Taoufik, it's wonderful to have you with us today if you're in the room. Our second panelist is Alfred Brownell. Alfred is an internationally respected environmental lawyer as well as a human rights advocate from Liberia. And for more than 2 decades, Alfred has been championing the rights of communities affected by resource exploitation all across West Africa. And he's also co-funded a civil society organization called the Green Advocates International Organization. And this is one of the region's leading public interest environmental organizations. It's also particularly amazing to welcome Alfred today because we had a great opportunity to work together alongside our comrades at PALU, as well as a broader coalition of African organizations who helped to shape and develop the petition that made it to the African Court. Our third speaker is Mary Morrison. Mary is a Kenyan environmental lawyer, as well as the director of a biophilic conversations organization. She's a woman. This is a woman-led platform that advances climate and environmental justice across Africa. Mary's work focuses on the rights of nature, ecological governance, and reparations, helping to shape legal and policy approaches that protect Africa's critical ecosystems. Welcome, Mary. We're also joined by Michael Kakande. Michael is the founder as well as the CEO of Resilient 40. This is a Pan-African youth-led climate justice organization. Michael is recognized as a climate leader whose work bridges climate change, human rights, youth leadership, and international climate governance. Michael, thank you for joining us. And finally, we are honored to welcome Dr. Patrick Toussaint. Patrick is an international environmental lawyer specializing in climate justice, human rights, and environmental governance. Patrick works with the African Futures Lab, advancing research and advocacy on racial justice, climate reparations, accountability. Patrick also brings extensive experience in international climate negotiations and policy. Welcome to you, Patrick. Please note that today's session is being recorded and will also be uploaded to the World Youth for Climate Justice's YouTube channel. So for those who are unfortunately unable to join us today, they will be able to participate as well as benefit from the discussion through that specific mechanism. And to today's online audience, we encourage you to engage throughout the discussion. Please share your reflections as well as your comments and questions in the Q&A function or the chat box. We'll be monitoring both of these platforms throughout the discussions, and hopefully we'll be able to then bring your questions into the conversation and table some of these questions for discussion to our panelists. So I'm really encouraging all of us to listen closely and intently, not only for discussions about legal developments, but also, I think, for the more practical pathways that these developments offer and how they can strengthen climate justice across Africa. Once again, welcome everyone. Without further ado, I'd like to jump into our first question for our first panelist. I'm going to turn to Patrick. Patrick, one aspect that has received comparatively little attention in the ICJAO opinion is the value of nature itself. Climate harm isn't only measured in economic losses. Across Africa, communities are losing forests, they're losing rivers, coral reefs, species, and ecosystems that hold immense ecological, cultural, and spiritual significance. I know some of your work focuses on this, and some of also your work also looks into the overall meaning into loss and damage. I want you to also help us understand, looking ahead, what role basically could the African Court advisory opinion play, and what safeguards are needed to ensure that climate finance genuinely reaches the communities that are most affected by climate change?
Thank you, Noma. I think there's a lot to unpack here. I would probably leave the question around nature or ecological dimensions to our learned colleagues. I think Mary is here as well. She's a specialist on it. But what I can tell you is a bit on what the advisory opinion essentially means for loss and damage, right? Especially for loss and damage finance. We have co-authored a policy brief together with La Ruta del Clima and Heinrich Böll Foundation on this very topic. And essentially, we argue that the ICJ's advisory opinion shifts loss and damage finance from a matter of policy, a matter of moral obligation, very firmly to the terrain of legal responsibility and accountability. So essentially, loss and damage finance is not only seen as a matter of charity or goodwill, as we're seeing now, for example, with the Loss and Damage Fund, but the opinions make it clear this loss and damage finance sits very firmly within the field of binding duties of prevention. You alluded earlier to duties of cooperation and as well duties to protect human rights. And crucially, under the law of state responsibility, where states fail these duties, they may be required to provide reparations. So to point to the UNFCCC, the United Nations Framework Convention on Climate Change, and just say like, look, there is this policy process on loss and damage. There are funding arrangements being fleshed out, and there's the fund. That is not enough. Just the existence of the fund for responding to loss and damage itself does not automatically mean that states have fulfilled their legal obligations on climate change. So I think the opinion makes that very, very clear. The opinion also makes it clear that states have a heightened due diligence to take all necessary measures and proactive steps to prevent climate harms. So, in plain English, that means the focus is here on the efforts that states actually make. Governments are required to use all the means at their disposal to reduce emissions and to prevent climate damage. And where states fail to exercise this heightened level of due diligence, the ICJ concludes essentially this can amount to an internationally wrongful act, and that can lead to legal consequences, including reparations. So, what does this mean for loss and damage finance? If climate harm is foreseeable, which it is, and if states know that insufficient and inadequately dispersed climate finance are undermining the resilience of communities, are undermining the response capacities of vulnerable nations, and resulting in increased loss and damage, which they do, then it becomes a lot harder to justify the current infrastructure there to respond to these climate harms under the loss and damage fund. So I guess what I'm trying to dig at, and what we try to dig at in this policy brief, is the fund itself should not be judged just by whether it exists. That's not enough. It's about whether it's adequately resourced, whether the funding is accessible, and whether it is commensurate to the harm that is actually being experienced. And that includes, as you alluded to, not just economic damage, but also non-economic loss and damage. I don't want to take too much time, but I also want to underline very squarely that the fund is also just one mechanism, right? It's one mechanism for cooperation to respond to loss and damage and to respond to climate harm, but it does not replace legal responsibility and legal consequences. And again, here the advisory opinions have really spelled that out. Under international law, states have a duty to cooperate. You have alluded to that also in your intro. And here the International Court of Justice explicitly links cooperation with mobilizing adequate finance. We find similar provisions in the advisory opinions from the Inter-American Court of Human Rights, as well as the International Tribunal on the Law of the Sea, which basically says like a one-off payment into the fund is not enough. You need consistent finance and finance that is commensurate. So if we look on the policy side at the fund for responding to loss and damage, and yes, it's a hard-won effort over decades of negotiations, led by small island states, that push being supported by developing countries under the Group of 77. Nonetheless, the current amount of pledges and actual money paid into this fund is in the hundreds of millions. If we look at estimates by the Loss and Damage Collaboration, actual loss and damage finance needs are estimated to be around 400 billion US dollars per year. So that's 0.1% in a fund that operates mostly through voluntary pledges. There's more other points that I can raise later on as we go into the discussion around things that may need to improve with the fund. But maybe to close off this opening bit, for the African court, there's obviously potential to build on these advisory opinions, not just the one from the ICJ, the International Court of Justice, but also the Inter-American Court, as well as the International Tribunal on the Law of the Sea. So we've recently published an amicus brief with the Center for International Environmental Law, looking towards reparations in the context of this advisory opinion. And I think an important point to make here is that the African court has the opportunity now to translate those principles that have been clarified by the International Court of Justice, but translate it into an African context, right? Through the African Charter, through African realities, and also applying it to sort of on a community sort of scale, looking at the right to self-determination, collective rights, not just looking at individual harms. The court can also clarify that climate finance must be adequate, predictable, accessible, and mostly grant-based. And very last and most importantly, from my perspective, it's an opportunity for the court to spell out that African states must protect, of course, on one hand, their people, but at the same time, they have an opportunity or perhaps a duty to pursue accountability and reparations from major emitters. I'll stop there. Thank you.
Thank you, Patrick. That was an interesting synopsis. I think as you were highlighting some of those integral points, something that came to mind was the fact that when we often discuss the issue of loss and damage, this isn't discussed within the context of colonialism and the fact that climate injustice didn't just emerge in isolation. It's deeply connected to histories of resource extraction, of dispossession, of inequality. And I'll definitely be coming back to you to kind of pick your brain into how we actually place those colonial histories into ongoing dialogue and conversations about climate reparations. Because you mentioned the advisory opinion in particular, I think it would be important for me to turn to Alfred now, perhaps. Alfred, you were among those who were at the forefront of the movement calling for this advisory opinion process. Can you tell us what the African Court's advisory opinion process is about? Why does it matter? How does it sit within this larger scale of this international process that occurred at the ICJ, and what kind of pathways could open towards reparative justice for African peoples and communities?
Thank you, Noma, and also thank you for the organizers of this webinar who invited me. I think this is a question that we have had to face many times in many fora where we've been invited, and the question has always been why, in light of the ICJ, why is the petition before the African Court? And I think those are very legitimate questions, and I will need to respond to. So just to be very clear in terms of the context, what we are doing in the African Court or the petition before the African Court is not an attempt to try to replicate the ICJ opinion. The petition and the opinion serve as a regional cornerstone for climate justice in Africa. And it builds upon, rather than replicate, the ICJ. And why the ICJ set an authoritative global standard for climate obligations on a general international law. It was structurally necessary to approach Africa Court for several reasons. First is that the need for going before the court requires an interpretation of the unique African Charter. The ICJ did not interpret the African Charter on Human and People's Rights. The African Charter contains explicit, legally binding rights. For example, Article 24, the right to a satisfactory environment, which do not exist in the founding text of the UN or other global treaties. It was also important to center collective and people's rights. Global human rights framework focus overwhelmingly, as all of us are concerned, on individual victims. But the African Charter uniquely legalizes the right of peoples as collective rights. This allows communities to seek justice for the destruction of transboundary natural resources harm. It was also important, we went before the court, to be able to contextualize what are the uniquely specific domestic realities across the African continent. As we all know, Africans still navigate unique compounding vulnerabilities, the economic issues, the climate-sensitive agriculture, mass climate-induced displacement and migration, we're all seeing. The famous photos of folks in the Sahara, in the boats on the Mediterranean. All of these issues are very, very unique. And so we thought it was important to be able to contextualize that a regional opinion would detect enforceable domestic rule tailored to these specific changes. Now, why is this opinion all about, right? Why is it this opinion? Well, our eyes was first and foremost for the protection of vulnerable groups, women, children, the disabled, indigenous people, and as well. We also sought to figure out how the court would be able to regulate third-party action, especially, for example, non-state actors or multinational corporations are involved in the extractive sector mainly, and the harm they created. We also were thinking about how do we advance the whole issue of the transition, the just transition process, that we thought that it could be able to map up a framework for transitioning to low carbon energy system while respecting social economic rights and ensuring the decolonization of natural resources governance. I'm sure this is an issue you brought out, Noma. I'm sure we'll be able to add on to that when we come out subsequently. And then I think finally there was the issue around the extraterritorial obligations, right? We thought that it could be able to clearly detect whether African states have binding collective obligations to demand that global historical emitters limit global warming to 1.5 degree and below and deliver adequate climate finance. Now, since the opinion hasn't come up yet and we are working through all the pleadings and paperwork, I think the real questions would be, what then are the anticipated pathway to reparative justice? Well, as you know, those of you who have followed the petition, it explicitly challenged the court to venture beyond just abstract declaration of harms and outline concrete parameters for structural climate-related reparations and legal remedies. So, for example, defining and quantifying loss and damage, which is a very important issue. We asked the court to move past simple mitigation and adaptation. We expect the court to set judicial standards for assessing both economic and non-economic loss and damage, including the loss of cultural heritage, communal history, and biodiversity. We asked the court to establish the whole questions around joint state accountability, to define the metrics by which African states can build third-party states, whole third-party states, and historical emitters legally accountable, directly bolstering state call for climate debt collective during, as you all know, the EU reparation decades of 2026 to 2036. There was also the issue of non-monetary reparative remedies. We hope the court could acknowledge that money alone is not enough, that legal advocates will anticipate that the court will establish pathways to restitutions, rehabilitation, and guarantees of non-repetitions. There's also the question of the protection or the issues of reprisals that climate activists, climate defenders, and the whole construct of a restriction in civic space that we've seen across the African continent. So we asked the court to formally recognize environmental human rights defenders as a legal steward. And under this expectation, we are hoping that protecting defenders from corporate or state-backed reprisals will be categorized as a necessary proactive remedy to prevent irreversible future harms. I don't know whether I've used up all of my time, but I will stop here and I'm sure we can follow up later. Thank you.
Thank you, Alfred. That was incredibly insightful. You mentioned that climate harm goes beyond these economic losses. It has an impact and bearing on a number of different types of stakeholder in a number of different ways that can't necessarily be quantified in a dollar amount. So that's your heritage, your culture. I think that brings me to Mary. A lot of your work talks about rights of nature. And is this something that you would like to see being inculcated and into the advisory opinion process within the African court, whether that's through amicus briefs? This is not something that received a lot of attention necessarily in the petition. And more broadly, should our courts be thinking about these types of losses that simply can't be measured in a monetary sense, such as biodiversity loss and a loss of culture as well?
Thank you, Noma, so much for that question. And I appreciate the fact that you're bringing in the context of nature in these discussions. In the general environmental law, what I've seen in most cases is, we look at human rights, we look at environmental rights in a way that is more human-centered, more than ecocentric. So, and I appreciate the fact that the previous speakers have mentioned about the AAO and what it set a foundation on. I know when you read the ICJAO, it doesn't really come out on rights of nature, but you can actually infer from it. And Alfred also quickly mentioned, he didn't dig deep into deep, which at least gives me that moment to dig deep into it, mentioned about Article 24 of the African Charter, which reads on the right to a satisfactory and healthy environment. He talked about rehabilitation and restitution, which like are all critical things when you're talking about nature. So to just take us back a step back into looking at how do we envision like rights of nature in the context of in the African context. So as I've mentioned, like environmental law, it's more like human-centered more than like ecocentric in a way. And you know, as you mentioned in the previous comment also, how like colonial hierarchies, like you can see how terminologies and African terminologies, how Western terminologies have been imposed even in the way we compute or even argue through our works in the environmental law space. So one critical thing I would want to highlight is the connections Africans have had with nature before. So it's not that Africans don't know what rights of nature is. It might be, you know, a term that is now like being known more, but a person who's been living at the coastal towns, they have been coexisting with nature. They know what nature is, and there is like a cultural and also to some extent a spiritual relevance in which they have been interacting with nature. So when we're talking about harm, and we mostly focus on the people, it dissociates to some extent the relationship between the people and nature. And that any actions that are taken that need to come and rectify any harm done to the people should also include rectification to the ecosystem. Hence, what they call restitution, rehabilitation actions, and not just merely compensation. In that way, it grounds us on us as Africans, how we see nature, how we perceive nature in our own tribal, national, regional way, in how we know best to perceive nature. So the as I mentioned, the ICJ has stayed, you know, didn't really, that question wasn't posed at the end of the day, but it's something that can be inferred from the advisory opinion, and that the African court can build into that aspect, into that aspect in the current AO. I still didn't see that come out as much in the amicus briefs that were filed, also in the petition in a way, but when you look at it critically, I'm hoping that the discussions, you know, that happen, you know, till the conclusion of the AO and the ruling is made, would definitely include the aspects of nature itself as ecosystems, and you know, ecosystems that have to be protected for cultural significance and for the relationship merging. Like, I would say the thing about reparations is, you know, from the word repair, it also means repairing relationships. And I feel that that might be a way in which we can get back Africans ourselves into in harmony back with nature. So it's hard to quantify losses because in this case, again, we'll go back to, you know, the hierarchies we already have. We're looking mostly at, you know, monetary. Whenever we talk about quantity, it goes to monetary aspects of it. And as Alfred mentioned, it needs to supersede that. It needs to, you know, it needs to go into actually recognizing that, you know, certain rights, not of the people only, but also of nature have been, you know, have been affected, and that, you know, it shouldn't happen again. It needs to have like a rehabilitative effort, which means yes to the communities and to vulnerable groups that have experienced the most climate harm, and at the same time as the ecosystems, these which communities, these ecosystems which builds the resilience of communities to climate change. So you can see the symbiotic effect of, you know, having a healthy ecosystem in a way helps manage climate change impacts to the vulnerable groups. So quantification, should move beyond economic, looking at it from an economic perspective. We cannot measure relationships, in the frame of economics. We can, and I know that's a hard question. It's something that also came up in a couple of other workshops, especially in the Kenyan context. Like, we have such a way in looking rigidly at things in terms of quantifying loss and damage. But then I do believe that, in my own personal opinion, I do believe like law is, we have to look at it in a wider sense, and in a way that it also applies to us. We have to look at it in a creative sense. We have to look at it at the African epistemic justice sense. We have to look at how does this apply to us. So in that way, then we are able to say like such an action of repair is culturally significant, and it builds and repairs the relationship as communities and as human beings we've had with nature. And of course, the rights of nature approach has been, we've seen it apply in other jurisdictions like New Zealand and other places. And to just anchor all this to see how would I envision this to anchor my entire argument. How would I envision this in the AO and also in national and regional legislation or in the courts? It's more looking again at, one, we have to acknowledge that we as Africans know what best is for us. We Africans are attuned to what methods of repair are. It's not that we don't know what repair is. We understand what repair is. It might not come in the language that is currently there, but it is something that we do understand, and that recognition puts us at the forefront of defining then what kind of remedies we would want to see. And I leave it at that. Norma, any further questions I'll answer during the entire call.
Thank you, Mary. That was quite interesting. My main focus is on your contributions about the difficulty with quantification in particular. I think as we sort of read the judgment coming from the International Court of Justice, it highlighted that whilst harm is something that's difficult to quantify, that's not something that should dissuade courts from dealing with these particular concerns. And what should be happening is a collaborative approach between lawyers and scientists, together with bodies that routinely put out research reports on some of these data sets on how our world is changing, whether that's our landscape, our biodiversity, our health in general. But I want to turn to Afik and ask him from the perspective of having analyzed the opinion coming out of that court, what kind of new avenues towards reparations did the ICJAO actually create? What did it highlight about how to prove harm and the difficulty with that? And what, in your view, I think has shifted in terms of the legal landscape of how we should start thinking about reparations in relation to climate justice? Taufik, are you?
So can you hear me?
Yes, I can hear you.
Sorry, I'm having some network difficulty. That's why I'm not able to share my my video and all. I can't. So with respect to your question, I think it's important to understand the significance of the AO itself. I mean, the UN General Assembly submitted two questions. Yes, the first one is the obligation of states to climate change, and then the second one is the legal consequence of the breach of such obligation. Now, issues about reparation sit well within the second question, which is the legal consequence of the breach, because you have to first establish the obligation of state to climate change before issues around breach and legal consequence can come up. So, and that was exactly what the ICJ adopted. So, in responding to first question, ICJ relied on the principle of state responsibility to state that states have binding obligation to implement their commitments under climate obligation. So what that does is to sort of elevate climate obligation to the realm of international wrongful act. So in terms of a shift, that particular clarification can be seen as a breakthrough for climate change law and governance. So clearly, climate change is no longer an issue of moral or political issue. It's now an issue of state responsibility, and especially under customary international law. So that breaches of the obligation of states under climate treaties are now considered as a violation of international law. And if that is the case, it means that the nature of that violation necessarily gives state the right to demand justice, demand action from the wrongful state. So when you look at it so the court recognizes state responsibility as an integral part of the climate change law and governance. It sort of elevates the obligation of state in climate change issues entirely. So from that point, you can argue that that clarification gives states, especially the small island states, the states in Africa, developing countries, countries who are at the front line of the climate crisis, even though they contribute, their contribution is negligible or insignificant to the climate crisis. They now have the moral authority, the political authority, and the legal authority. It gives them the leverage to demand climate justice from especially the historical contributors. So that is the immediate shift. Now, looking at the second leg of the question, the ICJ confirmed that violation of the obligation under climate treaties may trigger legal consequences. In fact, the court refers to it as a panoply of legal consequences, which is just a full range of legal consequences that can be incurred, especially under customary international law. So, in essence, while this finding or this clarification may appear novel, the reality is that, theoretically, this findings on reparation is not a new thing. The ICJ does not set a new reparation principle without clarification. What it did was to clearly clarify existing principles on reparation under international law, and only this time to climate change related remedies. So again, the immediate implication is that the advisory opinion sort of extended existing legal consequences to climate change. So you can see, using the principle of state responsibility under international law to situate and recognize the obligation of states in relation to climate change. Now, specifically on reparation, the AO recognizes three important elements of reparation. Now, the first one is restitution, compensation, and yes, somehow, the satisfaction. No, but with respect to there appears to be some issues when it comes to issue of proof or how states can, in a practical sense, demand restitution, compensation, especially those two. And in fact, the ICJ acknowledged the difficulty of restitution, especially in climate context. And this is so because if you look at restitution, seeks to, bring the environment or the climate system to pre-injury state. Now, in the context of climate change, this may appear a bit difficult in the sense that climate change could have a long-term and large-scale implication. For instance, small island communities who are suffering from sea level rise, it is difficult to adopt or use restitution as an important remedy in that sense. So there's a difficulty when it comes to large-scale environmental harm. Yes, I agree. If it is a localized damage or damage that can be easily remedied, restitution may appear possible. But when it comes to long-term and large-scale harm, restitution is limited in terms of the remedy it can provide. And the ICJ acknowledged this difficulty. Now, the next one, which is a compensation, and to a large extent satisfaction, appears to have a more practical and immediate implication. Now, by recognizing this reparation principle, it means that states and indeed victims of climate change, especially the vulnerable states and vulnerable communities, now have a range of remedy. The first one is restitution and satisfaction and compensation. So in terms of the implication of the AO again, we now know that the existing principle of reparation under international law also extend to the climate change. So I think that is an important issue. That's an important pronouncement. That's an important clarification. Now, compensation, which appears to have a more practical implication, also has challenges. Because anytime you are talking about reparation, the major challenge is the problem of causation, attribution causation, and as you mentioned, quantifying, that's quantification in connection to climate change. And that is a big problem because anytime you talk about compensation, the court usually demands for proof, the evidentiary proof, and how the proof were arrived at. So that is a big issue. But then the ICJ acknowledges this difficulty, this challenge. But then the court highlighted the point that equitable remedies, equitable consideration, and even estimate can also be adopted. So the court, in essence, is trying to shift from the stringent requirements of causation to accommodate issues where strict proof may not be possible. So for instance, we have the science is already clear on climate change, and impacts of climate change such as flooding, sea level rise can be immediately established to be, with science. That is not a problem. So in establishing this impact, you don't need to establish causation. But when it comes to attaching those impacts to individual states, causation is very important. And the court noted that it has to be established. In fact, it cannot be waived, as argued by some states. So it is very important to establish causation in order to apportion blames and all, and yes, if you like. So that is the major issue for causation. Now, you did not mention satisfaction, because satisfaction also has its immediate implication. Like
That
Mr.
thought,
Alfred,
sorry, just on that thought, Taufik, you outlined a number of really important legal principles, and I think what is also useful is thinking about their practical application on the ground. And as you outline the differences between restitution and compensation and reparations, I'm thinking about the voice of the youth in this discourse and what that actually means for them in a tangible manner, what it means, what reparations meaningfully look like for future generations. And I know that Michael works at the forefront of youth leadership with his organization, Resilient 40, where you promote themes of intergenerational justice. So I think I want to pull Michael in for some additional thoughts here on that. Michael, can you help us understand how should intergenerational equity shape these discussions around climate reparations that Taufik has so aptly outlined?
Well, thanks so much, Norma, and thanks for the team. Very awesome, great submissions from the previous speakers, and wouldn't add much onto what they've really submitted. Awesome submissions and assessments. Well, looking at the not so perfect ICJ advisory opinion, given the previous submissions, and you find that it's still a significant step, forward, because it confirms that climate change is not only an environmental or political issue, right? But it is fundamentally a matter of justice, human rights, and legal responsibility. And of course, by recognizing that breaches of climate obligations may require, cessation, let's say guarantees of, non-repetition, like Dr. Alfred said, and full reparations. The court really, helped strengthen, the legal basis, for frontline communities, that are probably seeking accountability, given the realities that we see, across Africa and elsewhere in other parts of the world. And for Africa, basically, one of the greatest challenges, in climate litigation will continue to be proving, as my brother's been saying, Tawfiq, and, quantifying climate-related harm. And as we know, climate impacts are usually cumulative and, transboundary. So sometimes very hard to track and often, unfold over a very long period of time. So you might find that it's going to be a struggle, even with so many young people we work with all across the continent. Young people have been, standing up against so many, governments and projects, but it's always, proving the cause and quantifying such climate-related harm. But of course, one would say, advances in, science, what they call attribution science, climate data, as we know, and human rights jurisprudence, are making it increasingly possible to demonstrate the links between emissions, climate impacts, and the resulting harm to communities. And of course, courts, our push has always been on courts, should really try to adapt approaches that reflect these scientific realities, and of course avoid imposing those evidentiary burdens that make justice unattainable in a way for those that of course over time have been very least to or minimal or not at all responsible for the climate crisis that we see today. And reflecting on Mary's submissions, I've been privileged myself to be in several rooms with the IPCC chair and the science teams. And every time they present their awesome science, I let them finish and I get the mic. And I've always asked them, so which part of this science is informed by indigenous knowledge? And they've always looked at me and like, Michael, that's the part we are missing. So yes, there's science there. It's sad that I always call it Western science. but there's science there that is still, missing a lot of our, our own, aspect of our indigenous knowledge and how we've managed to succumb or overcome these challenges over time. So, as youth now, talking about young people and children and these young people, we believe, of course, we personally believe that intergenerational equity must be at the heart of climate reparations. If we are really talking about climate reparations, then intergenerational equity should be central to all these discussions. And of course, young people and, children and the unborn probably are inheriting a crisis. Of course, as we always say, they did little to create this. And of course, future generations will live with the consequences of today's decisions. As we see, people like Trump in office, far right Europe, and Africa becoming a mess every other day. You find that reparations should therefore, go beyond compensation, right? For past losses, but they should really, invest in resilience, rights and opportunities for future generations. And of course, the African Court, on human and people's rights has a unique opportunity here, to articulate on, the African vision of, climate reparations and making sure that it is grounded in solidarity, like the previous speakers have highlighted, equity and the right to development, because it is very important. Because even in the advisory, in the petition for the advisory opinion at the African Court was the issue of carbon markets. So there are so many projects that are thrown onto us, but we find violating, so many rights to, indigenous people, indigenous communities. So, of course, for us, young people, a meaningful advisory opinion would really, try to affirm, that reparations include, restoring degraded ecosystems. We have plenty of these on the continent. And of course, financing climate adaptation and resilience, like Mr. Patrick had really clearly highlighted. And of course, supporting, loss and damage responses, safeguarding water and food security issues. Right now there are people in Africa starving, in Uganda and other parts of, the eastern region. People are starving even as we talk right now. Protecting indigenous knowledge, which is very important, highly undocumented, but we need to really even protect it. And ensuring young people have meaningful participation in climate decision making. And of course, with this advisory opinion, it could help recognize that reparative justice requires, predictable climate finance, like Patrick highlighted, but also technology transfer. The issues of capacity building to enable African communities and African countries, build this climate resilient future that we so much talk about. So that way, for us, meaningful reparations are not only about repairing yesterday's harm, they should be about preventing tomorrow's injustice, because there's too much injustice as we are witnessing in communities and all these policy spaces where we try to push these voices. And it really, if the African Court places children, youth, and future generations at the center of its reasoning, we are really, we really hope that it could probably help establish really a transformative framework for let's say climate justice that reflects Africa's realities, while shaping, that global that global legal, platform, for generations to come. So if you ask me, and from my experiences engaging within the spaces and with a series of young people all across the continent, that's what quickly would run to my mind. So I'll push it back to you, Norma. So thanks.
Thank you, Michael. I think that brings me to my next question. And this one I want to open up to all of the panelists that are joining us today. We've kind of scoped out why there's a moral as well as now a legal argument for reparations. And we've highlighted how we want those reparations to sort of the form and the shape that we want those reparations to take. But I think something that we haven't discussed is the practical and legal challenges and obstacles that might come our way in trying to secure these reparations from the perspective of communities on the continent. And also, again, the historical context that shapes the current status quo that we're living in respect of the fact that for us to get these reparations and acquire them, there has to be some sense of political will. And this is very much sometimes a global North, global South dialogue. Our friends in the global North should have maybe been incorporated into this webinar so that they could share some reflections about what that could look like in a fair manner. So I'm going to go back to Patrick, I think, first to hear what his insights are. I'll then move on to Alfred to share his thoughts, and then to Mary, Michael, and then to Taufik. So I'll give each of you about 4 minutes to respond to that.
Thank you so much, Noma. I think I'll be way shorter than that. So I cannot speak to communities, but what I can say is the sands are shifting, at least at the sort of global policy level, right? When you work on climate reparations, you also look left and right and you see, okay, what is happening in the traditional reparation space? And as you all know, I'm sure the United Nations General Assembly adopted this groundbreaking resolution on slavery and the slave trade, declaring it the gravest crime against humanity. So this is already a major milestone. We have the African Union's decade on reparations under the leadership of Ghana. Unprecedented sort of regional political momentum behind this push for reparations. I think it was last month, there was this conference called Next Steps, basically how to put that UN General Assembly resolution into practice. And you had leaders from the Caribbean, Mia Mottley was there, you had African leaders coming together, you had European leaders there, perhaps grudgingly, but there is suddenly, it is becoming more acceptable to talk of reparations than maybe it was a while ago. I remember joining different climate justice related events, and there was a person who was like, "Oh, we shouldn't be using the C word." I was like, well, "You mean colonialism, what, or even reparations? Like, why is that not something that we can talk about?" I think we've kind of moved past that. So just to say, I think there is unprecedented political momentum, and it's something that needs to be harnessed. Even if at the policy level there's more and more openness towards making reparations a reality, of course the challenge is how do you translate that on the ground, right? And especially in the context of climate reparations, what does that mean to communities on the ground in the first place? I'll close with this. We are working with partners as part of a strategizing and collaboration space that we call the African Climate Reparations Collective. And this is exactly the kind of work that we want to do. We want to build a common narrative, a Pan-African narrative around climate reparations. We want to put our ear on the ground and listen from the experiences of communities and learn from them. Okay, how does reparative justice fit into African context? What does it mean to a community when you talk about climate reparations? Sort of abstractly, like how do they translate it into their own languages? But at the same time, also making that bridge between sort of research, policy, and community experiences. And we are all gathering in Mombasa in September for a symposium to do exactly that. This is not like a top-down conference, it's the opposite. We are coming together, we're co-creating. So do get in touch if this is something you're interested in shaping with us. Thanks, Noma.
Thanks, Patrick. And you make a great point about the fact that these advisory opinion processes get a lot of flack for being processes that can only influence and are not necessarily legally binding. And it's up to us as lawyers, as activists, as journalists, civil society, organization representatives, people in different sort of spaces to come together in these platforms that you've already kind of highlighted to see how we can inculcate some of those findings into policy, but also maybe into legislation or jurisprudence in our case law. The idea is that the actual judgment is being quoted whenever there's a precedent-setting case in South Africa or Kenya or Ghana, or within the perspective of a regional sort of process. And I'll bring Alfred in now to highlight maybe some of his thoughts about the more regional outlook at integrating some of these ideas on reparations. Alfred.
So thank you, Norma. I think the first thing that comes to mind when you talk about reparative justice, especially, as Africans, as the messenger, it's always like, oh, these poor Africans, they've come to beg again. It's all that we do. We just go around begging and we're seeking aid. But to understand how reparative justice fits into the African context, we must be able to see it. We must be able to decolonize this process. Because I think it is a colonial construct that when you talk about reparation, you get to be seen as a beggar or you're seeking development aid. But once we decolonize reparative justice, climate reparations will not just be a charity or development aid anymore, right? It would be that Africans are seeking the legal and historical debt owed for centuries of resource extractions, colonial eco-extractive destruction, and the sort of greenhouse gas effect that we're seeing across our continent. And because we, as established by the science, as one of the speakers have said, contribute the less and are the most vulnerable, reparations justice is seen within the context of Pan-African solidarity. Communal and community, especially frontline communities, eating reparations, and also the whole construct of resource sovereignty in terms of how climate impact have implication on biodiversity, on culture, on landscape, on river ecosystems. Now, how, like one of say, how does it fit within our African context? I think what we're trying to pursue, and we're hoping this is what the court will be able to opine on, is that why the Western legal framework will focus on proving harm to an individual person or property. We are hoping that the African Court jurisprudence will anchor the African Charter that will recognize, as I said in my previous talk, on people's rights. That there will be an intersectionality between the advancing this whole reparation process with the AU reparation decades of 2026. We could not have filed this petition at an opportune time. I think the clear connection between the advisory opinion that will come from the African Court and the AU declaration, I think, is so relevant now. I think also this will help to eradicate the whole question of colonialism. We are hoping that the opinion will be able to address this so that there's clear, unified legal standard, so that when African negotiators and African governments and African civil society are making the case for reparation, they have clear legal binding from the African Court. I think there are a couple of actions we could take. I think helping us to conduct community-led human rights audits would be very helpful to establish those processes. Mobilizing the whole question of, as someone has said, the whole green grabbing that we see here now, the carbon markets that's been established across the continent would be extremely helpful. We're hoping that, under this petition, there could be litigation, there could be legal reforms, there could be the whole question of debt for climate swaps. And across the African continent, we can figure out how, leveraging Article 24 of the African Charter, that communities themselves can bring collective lawsuits to the African Commission, to the African Court, that we can utilize regional economic code like ECOWAS, like the ECA and others, and then also we can be able to submit evidence. Thank you.
Thank you, Alfred. I think I would like to bring Mary in. From your vantage point, there's a lot of, it's not settled, the idea of the rights of nature globally. What do you think are the biggest legal and practical challenges to securing reparations within the context of your expertise and your knowledge from that vantage point?
Yes, thank you. This is something that was also personally a struggle to me. And one of the biggest challenges I see is because of the fact that we had, and I'm sorry, I will have to say the word colonial hierarchies a couple of times, but because we have that system of colonial hierarchies that are still present till that means that our education, our ways of relating to nature have been, the relationship is a bit severed. And I'll give an example of like, at growing up at some point, we didn't think like farmers were stylish, like it was a job someone wants to do. We didn't perceive some certain, ways in which we related to environmental protection as something that, that should be, fought for, should be like at the forefront. We don't have like environmental conservation like proper embedded in our curriculum. But you can actually see that in the Western world that there are environmental programs in curriculum. So that being a challenge, like the system itself, the way it's set up, it's not set up that it helps us understand. We have to finish school, then go back and start dismantling what we've already been taught, so that to understand that, the way our ancestors prayed to rivers, to mountains, the way my ancestors revere the ocean does not make it, what we were called witch doctors, and it's a way, the nuance in which we have to go back. I am a pro for the Sankofa principle, which is basically West African, but I do apply it in my East African context of like, as much as the injustices we suffered and, colonial hierarchies, and we might not want to go back and look at the heaviness of the word reparations then is, we still have to go back, look back and see what is it that we had that was lost. So then when we're making for any changes, we have to consider that was lost, that can be repaired. So that's a challenge and a recommendation that I would say in my work. And that means that with the relationality with our ecosystems and the way that we treat the ecosystems, it will definitely trickle to that. And we do know that with our ecosystems being healthy, it builds into our climate resilience. We have to look at ourselves for the solutions. We are contributing less than 4% of the emissions, but we are getting the most impacts. And then while we are struggling over loss and damage fund and adaptation financing, not even trickling down to the community members, we then now have to tie back to ourselves and see what is the appropriate way in which we can have the relationship with ecosystems that can enable us to build resilience. And one way in which we are having this issue of climate change and everything, it's not only the emissions that are out there, but also the devastating degradation that you can see, like let's say, like I don't want to go into minerals, but we all know like what that causes in the African continent, and it's kind of a way in which we do not even respect nature itself as a living entity. That means that we need to repair within ourselves that type of relationship before we even go further to advocating for other measures. And I will end this by stating that in a conference I was asked about that question, or we are talking about colonialism, and it's like, begging when you're asking for repairs. And I simply said that my Africa is the only place that is my business. What the other people think, it's honestly not my business. And what I can contribute to that is that what can we as Africans do that we can repair for ourselves? And that includes an understanding of the injustices that really removed us from nature itself, nature that is critical to our own spirituality and to our own souls. And at the same time, then at that point, we can be able to advocate in a joint way. And we are seeing this even now with the decade of reparations, with the current UNGA resolution. And I do believe that it's like it's not a new dawn per se, but it's a new decade where we can really influence change in the space. Yeah. Thank you, Norma.
Thank you, Mary. I think that's quite a strong contribution, talking about sort of our psyche as Africans and on the continent, just highlighting how we have to understand what we've lost in order to be able to make a good legal argument about why, therefore, we should be compensated for those losses. And that means that we need to inculcate this knowledge into different educational pathways. So into our psychology degrees, sociology degrees, our legal degrees, health sciences degrees, all that learning about customary law and indigenous knowledge, all that should kind of be knowledge should be inculcated into the offerings that are already there, because they tie into so many other disciplines. So I agree with you on that. I'll bring in Michael. Michael, you've got about 3 minutes to share your insights before we hear from Taufik.
Well, it's a very very interesting topic, and one that has always disturbed my mind because, drawing back to, okay, if German could pay reparations to Israel for what they did, how comes every time an African has to ask for the same, then you call us beggars? It's a very interesting topic. But to conclude it in a few words, for me, I think colonialism definitely cannot be treated as a footnote in discussions on climate reparations, right? Because it should be recognized as part of the historical context that shaped today's climate injustice, because it is in the first place. Of course, the extraction of Africa's natural resources that Mary has been highlighting too, the exploitation of our people as we know it, the economic systems established during the colonial rule that generated wealth, that fueled, industrialization on the other part of the world, that has contributed significantly to what we see today. So there's no way we can separate that the topic of colonialism with the aspect of climate reparations. And for me to put colonialism at the heart of climate reparations is to acknowledge that the climate crisis did not just emerge out of what can I call it, a historical vacuum of sorts. Something brought this about, and it requires recognizing that historical exploitation combined with the ongoing inequalities in trade, finance, technology transfer, technology access, as well as decision making, has left so many African countries disappropriately vulnerable to climate impacts. Despite that, we've not been emitting as much as they have, close to nothing. And of course, climate reparations must be therefore address not only the consequences of climate change, but also the structural inequalities or the structural injustices that have limited Africa's capacity to adapt, build resilience, as we always talking about, build resilience, but also that has limited us in pursuing sustainable development. And this is where the African court really has substantive unique opportunity to really articulate on what can I call it, on the African understanding of climate justice. So yes, there is no way those two are separate. Colonial has to really be integrated into the aspect of climate reparations. And when you're talking about climate reparations, for me, it seems like it should be about restoring opportunity, right? Because for so long, we are in these spaces, people have been talking, this is COP31, we're having COP32. What has happened? What has changed? Nothing. So these are all structural systems, structural injustices, but when you look behind them, there's a colonial mindset as to why we are in COP32, but we are totally or not even reaching any agreement after 31 or so of negotiations. So young Africans, honestly, should never inherit both, the consequences of historical exploitation, but as well as the escalating impact of climate change. For us, that's what we are saying. And if you're talking about reparative justice, it should really look into investing in education, like you rightly said, the aspect of green jobs, resilient food systems, clean energy. It is so shameful that with a lot of sunshine that we have in Africa, we have energy poverty issues. That's craziness. And, sometimes, and meaningful participation in climate governance. We are making noise. We want a seat at the table, but even African Union is struggling to have a seat at the table. So how about us? So these are all colonial patterns. And for me, if there is anything, it's then the African court that has an opportunity to shape that transformative vision of reparations, right? And one that would really look at recognizing that historical injustice, while also focusing on building a more resilient future for Africans by, of course, placing colonialism within the legal and the moral context of climate justice. So that's what I would clearly say, and push this back to you, Norma.
Thank you, Michael. That was well put. Our last speaker is Taufik. I guess my question for you is you've outlined to us what the priority principles were that were coming out of that ICJAO advisory opinion judgment. Should we be hopeful? Is there anything that we should look out for in terms of them, of aspects being guardrails towards us realizing this hope and dream for us acquiring reparations? What should we be mindful of, even though we are hopeful that this judgment will hopefully integrate itself into our jurisprudence in a more local fashion? How do we balance our expectations, I guess is my question, realistically? Taufik, are you there?
Just quickly, I know we are already running out of time. So the first thing we need to understand, and I would like to put this into perspective, is that when you talk about climate justice, especially in Africa, I think we sort of have a bit of maybe misconception when looking at it from the global north and global south perspective. For Africa, we need to really reconceptualize the idea of climate justice, because we face a sort of a peculiar problem. Climate justice for us is not just the problem with the climate system. It is a developmental issue, it's a cultural issue, it's a colonial problem. So when we are talking about the concept of climate justice in Africa, we have to look at it from that perspective, so that when we are providing a solution to it, it can be all encompassing, because the same people who are already suffering from socioeconomic problems and now also have to face the problem of climate change. Go to the rural communities, you see this problem. Now people are now being displaced. Now we have conflict. All these are exacerbated by climate change. So I just want to put that into perspective. So now, in terms of our expectation, well, the first thing that you have to understand that the ICJ, even though it's not binding, it's not legally binding, it has a strong moral power for states. Now, we are all discussing the impact of that ICJ. The state government are now discussing it. The small island nations, developing countries, it has given power to states to demand justice from the standpoint of rights, human rights. So it's not just a moral issue. People can now use it to make argument on human rights. People can use it to argue for state responsibility. People can demand action from government, that states must act with due diligence when it comes to protecting environment. So that, again, is a practical step in which community can demand, states and community can demand justice from it. So the expectation is there. And then for the African court, I think it's an opportunity to actually look at it from the African perspective. We want the African court to give us an opinion that reflects our own reality. At the existential threat that we face, we want them to conceptualize climate change within the context of Africa. We are facing an existential problem. The global north may not really understand this problem the way we are pushing it forward. We don't want them to separate climate justice from environmental justice. All of them must go together, because they are one and the same for us in Africa. We don't want that dichotomy, because often you hear people talking about environmental degradation, pollution, all of them together, they are climate injustice, they are environmental injustice, and we as Africa, we bear this brunt together. We don't want any separation anymore. They are colonial problem and they are existential problem. So I will just stop at there. I understand there's no more time. Thank you.
Thank you so much. And thank you to each of our panelists for such thoughtful and insightful contributions. What has emerged so clearly, I think, from today's discussion is that climate reparations are not simply about addressing past harm, they're also about shaping a more just future, like Michael said. We've explored how the ICJ advisory opinion has really strengthened the legal foundations for accountability and some of the opportunities as well that have been presented by the forthcoming African Court advisory opinion that Alfred articulated much about. We've also heard about the role of climate finance from Patrick, the recognition of nature from Mary, as well as the rights of future generations, and the importance of confronting the colonial histories that continue to shape today's climate injustices. I want to turn to our audience. Thank you so much for your engagement throughout the session. We took 90 minutes of your day, but I saw a number of you were quite engaged throughout the session, so thank you very much. I want to turn to Samira now for our closing. Samira, if you're there, back to you, I guess.
Here, can you hear me clearly?
Yes.
Okay, great. Thank you so much for everybody who joined today's sessions, and obviously for our amazing panelists. After a few hurdles at the beginning, but you all were very, very brilliant, and really enjoyed the sessions. Now the time is running out, unfortunately, so I would like to finish with what we often do with World of Climate Justice, which is a call for action. First, I would like to invite everybody to look into the implementation toolkits that we have created, specifically Nicole Ponce, our advocacy coordinator, has created, that is recapping all the advisory opinion that we have so far, the ICJ, the Inter-American Court, the ITLOS one, and also some of the resources that we have on the African one. It's more than a resource, it's really it's a living resource. It's something that we want to make sure that everybody is able to use on an everyday basis in their advocacy towards getting climate justice. Then I would also like to invite everybody to follow some of our social media and keep yourself updated on what is or what are the new legal development case studies and implementation pathway that we are seeing emerge. And I would like to invite you to actually be actors of those living developments and share them with us if you see them, so that we can add them to the toolkit when we see them coming. If you're working on implementation, whether it is accountability, litigation, advocacy, or policy, we would love to really hear what you are doing and how you're using the ICJ advisory opinion. And we also want to invite everybody to join our newsletter to also have a few updates on the campaign. Lastly, I would like to share an update. We are launching a campaign really soon that is called the 193 Please campaign for climate justice, where we will be petitioning governments across the globe for resolution that not only are acknowledging the ICJ advisory opinion and other advisory opinion, but are also making sure that within their own policies, structures are being put in place for implementation. We already have seen a huge success with a resolution that happened in the Philippines, so we'd like to reproduce the same thing across the board. That's it on my side. Thank you so much